are ill-treated. It is a matter which is undeniable. Undeniable. I am saying a lawyer, I myself a lawyer, 65 in the bar for 4 decades. I can vouch for it. And therefore, I could have been silent. I couldn't have just, be silent and mute spectator, but I have decided to be different. The judicial reforms is a must. And we should have a system where, look here, don't think that I am criticizing judges, certainly not. See, the Supreme Court dismissed SLP in 93 seconds. But I don't blame the judges. All the judges are all hardworking. They are working they burn the midnight oil. So put so much effort. Nothing is denied. But the fact remains here is that, see, when a board is discharged, I tell you, in the Supreme Court last week happened. I was there. My item was 62. The board was discharged. Hari Salve matter was taken up. The whole day it took, and my matter didn't reach. So therefore, when the Bombay High Court, see, every day you find board is discharged when somebody comes, and you look at cases are being taken out of 10. Look at that. Even a bail application in Bombay High Court, it's not given a listing after a month. In fact, I had to fight for a listing of a matter where somebody was in jail on a petty offence for months. So that then even after I took the cause of another lawyer friend of mine, and a posting was given after 4 weeks. So on the contrary, look at the case of India Bulls, Adul Jabri and all, and a case involving siphoning of thousands of crores of rupees. And matter was taken out of 10 and heard, interim injunction was granted. Then thereafter it was taken out of 10, it is finally heard and disposed of, and money laundering involving thousands of crores of rupees. So therefore, this is because judges are, when a senior lawyer under the current system, they have enormous crowd of power. The judges are helpless because the senior lawyers, they are one powerful group. They are so powerful group. They are one family, one class, one elite group of people, and they prevail over them. They see what their opinion, unfortunately, is what reflected in the press. Their opinion is the opinion of the, even I would say, even the court. Because otherwise how could a parliament enact a NJAC Act, and it was the will of the people, it has received the both houses of the assent of the both houses of the parliament and majority of the state, it was thrown to the dustbin. So therefore, now this reformation, the designation system, the abolition of designation system, the abolition of the collegium system, the abolition of the transfer of judges whose immediate relatives are practicing in the court, in the court where they are judges. And I in fact I had to suffer. I had to invite the wrath of the court, and I had to suffer, because I took up the issue of Fadi Nariman practicing in the Supreme Court, where his son Rohinton Nariman is a judge. So those I have suffered. I have been victimized. I have been attacked, but I have nothing. I don't keep anything against anybody. Umsor, Hamdi treated me badly or attacked me. I have only one day, Lord, forgive them, for they don't know what they are doing. I have nothing. I don't keep anything in my mind. Now coming to the solution aspect. See, there is no estoppel against law. A judgment of a court, at the most, where the facts are involved, is binding between the parties. In this case, there is no factual decision. There is no residuicata. So I was a party to petition. Now, even I am concerned also, there is no estoppel, because that estoppel means a matter which is finally adjudicated cannot be re-agitated. So there cannot be an estoppel unless facts are involved. A pure question of law has no estoppel, and that is a fundamental principle. If anybody has a doubt, go to CPC, Order 7, Rule 11D, which provide for rejection of a plaint if there is a bar, and Order 7, Rule 13. Rule 13 says a same suit between the same parties on the same cause of action will lie. Why? The rejection of the plaintiff will not act as a res judicata. So the concept of res judicata has no application. I can file the very same petition. So in our case, Manisha's issues were not considered even. Grievance of, there is not even a whisper in the judgment about the injustice which she as a petitioner has been subjected to. She is an agreed person. She has a case that she was, her lawyer was not given the fair treatment because he is not a designated lawyer. And he has seen similar fate with thousands of hundreds of litigants. So she, in a way, symbolically represents this litigant class, and the judgment doesn't have even a whisper about it. Now, therefore, the judgment even will not bind her as a res judicata because there is no decision on the facts. And when it comes to law, there is no estoppel against law. There is no law, has no finality. Today you decided. The Supreme Court in the 13 bench judges of the Supreme Court in Keshavananda Bharati said the basic structure cannot be amended, even by a constitutional amendment. That principle, that is absolutely wrong. Why I say it's absolutely wrong? Because what is justiciable is cause of action. What a court's duty is to adjudicate disputed cause of action or rights. So before Keshavananda Bharati, people used to go to the Supreme Court saying that my fundamental rights are infringed. So therefore the court is competent to grant remedies, right remedy forum. After Keshavananda Bharati, what happens? The Prashant Bhushan and the company, they go to the Supreme Court, assert that none of my rights are infringed. The basic structure is infringed. So they come to the court without there being any legal right being infringed. So therefore, the Article 30, the PAs are all entertainment of, petitions by busybodies. And unfortunately, in many of the news reports, even about this petition challenge of the Senior Designation, it is said Nedumpara's PAL has been dismissed. I never filed any PAL. I file a petition if I have a right. I filed the petition in challenge of the Senior Designation asserting that my fundamental right under Article 14 and 19 and 21 is infringed. And my NJAC case, that is also instituted on the premise that my right for fair treatment has been, equal opportunities to be considered for appointment in the superior courts have been infringed. So therefore, this judgment though is a disappointment, certainly does not constitute any bar and will not restrain us from prosecuting the matter further. So we will take an appropriate decision. So many people call me, either we will file a review petition or we will file a fresh petition. I think review petitions are all dismissed in chambers and no opportunity of hearing being afforded. And fresh petition we will file. The issues need to be readdressed. If somebody asks for a precedent, is that judges one case and judges two case. Judges one case, the 7 judge held that the Chief Justice's opinion of the Chief Justice of India means only the opinion, and it is does not mean anything beyond that. Before the ink of the judgment was dry, repetition was filed, and the issue was reopened, and thus came the Judges 2 case of 1993. So I believe the court will certainly realize its mistake, and it will be open to correct itself. And I am sure a large number of people will join in our campaign, and the Supreme Court will reconsider the matter, and this decision, which is a manifest error, will be corrected.